If you're a user of the Scripture Union's daily devotional, the Daily Power, this morning you would have read that God shows mercy to people when they act in ignorance and admit their faults. But you would have read in the same commentary in the Daily Power that there's a legal principle known as ignorance of the law is no excuse. Now, since the coronavirus pandemic, Ghana has enacted a number of laws. We have had the Imposition of Restrictions Act 2020, Act 1012. It empowers the president to issue several other loosely called laws, president-only made laws. They are known as executive instruments. The president has issued executive instrument number 61, 62, 63, 64, 65, 66, 67, 68 to 110. These have changed our lives. But what do you know about the changing laws to avoid the consequences of violation or non-compliance? How do you comply to also secure your own safety? Let's have your questions. These are the issues we are dealing with this morning, helping you to know the dozen COVID-19 laws in Ghana. People have gone to jail for not following them, perhaps just because they were simply ignorant. We'll be right back. Welcome back. This is Covid and the Law, your legal light and help law in these difficult and trying times. Now, let's quickly do a recap of what we had last week. Last week, we were privileged to have Hanifa Yaya Esquire, managing partner at Hay and Partners, and we treated the problems coming out of your tenancies with your landlords. Here are the takeaways. Landlord and tenant relationship is governed by contracts signed by the landlord and the tenant. The best that this ought to be in writing. But Ghana's laws on rent and its regulations, as well as conveyance, also regulate the relationship. Demanding more than 6 months' rent is an offense punishable by a fine of up to 2,400 Ghana cedis or plus 6 months in jail. If the tenancy expires and the tenant is not able to vacate the premises, he becomes a statutory tenant, acquiring the status of irremovability. A statutory tenant must pay rents, monthly profits each month on the terms of the expired contract. A statutory tenant cannot be evicted from the premises unless by an order of the court or the rent magistrate. If you compel your landlord to resort to the court, you may get only 3 months as grace period to find alternative accommodation and get evicted. The tenancy agreement must be in writing with terms including express covenants on the duration of the tenancy and the rent payable. There are implied covenants including payment of rates, utilities, and waste management. A key covenant a landlord must observe after the tenant has kept his part of the covenant is to ensure that tenants get quiet enjoyment of the premises, and landlords must be sensitive and sympathetic in these COVID times when people are losing their jobs and getting salary cuts. Tenants must act faithfully and sincerely. We will go for our news round.
I've directed the Attorney General to submit immediately to Parliament emergency legislation in accordance with Article 21(4)(c) and (d) of the Constitution of the Republic to embody these measures. And I've further directed the Minister for Health to exercise his powers under Section 169 of the Public Health Act 2012, Act 851, by the immediate issuance of an executive instrument to govern the relevant profession. I call upon Parliament to support the executive in this national endeavor.
President Nana Akufo-Addo had to review measures including instituting an emergency legislation when cases of COVID-19 were increasing. But some Ghanaians found it hard to comply, leading to their arrests. However, their arrests were questioned when the imposition of the Restriction Bill 2020 hadn't been passed. The Attorney General, Gloria Ekufu, laid in Parliament on 18th March 2020, but it was not without opposition from the minority.
If we want to put aside our standing orders and the Constitution, because Article 104 says so, because we take an objection to the fact that the leader will tell us that people were walking into. So don't report. You have 169 members. Where are they? Where are they? So if you don't have numbers to take a decision, don't force it. Mr. Speaker, we are going to insist on a recording because we challenge this matter in court and the ruling. We will. Because the outcome of the vote. Thereafter, you have referred the matter back to the committee. So we've gone past that. Where we are, the Speaker, if anybody wants to challenge what you have done, the person must come with a substantive motion. That is what the rule provides. And go to the coffee shop. The people are there. Go there. They are there. When you deliberately evacuate the chamber.
This bill is intended to provide a broad framework to deal with future occurrences of a similar nature. Mr. Speaker, if you are intending to lay a framework to deal with future emergencies, I think it is only fitting and proper to take steps to build a resilient legal system, a resilient regime to deal with that. And that's why we ought not to take this under a state of emergency.
After hours of debate, the imposition of restriction bill passed on 20th March 2020.
You're welcome back. This is Covid and the Law, your legal light and health law in these trying times. Now, our guest this afternoon is a senior lawyer and we should be grateful he's made time to join us this afternoon to help us understand the law. Help me welcome Kweku Pencil. Thank you very much for making time to join us, sir. Right. So we, as already announced, we are going to spend quite considerable amount of time to help you understand the laws as have been passed by Parliament and as the President has also issued the EIs. Kweku Pencil is the managing partner of Pencil and Pencil Pencil and Co. Because of the special nature of today's show being purely educating you on the laws, we don't have case of the day. But some of you have sent in some questions that are very useful. We will throw light on them to help in the process. So, a first question coming from Sylvester. He says, "Hi Samson, which of the EIs give right to the Ministry of Communication NCA, Kelny GVG for our data on calls, Momo, etc.?" So Sylvester sent that one in from Kede. Arnaud Charles is asking, all these laws should have a lifespan of the crisis it seeks to handle. Once the crisis is over, it should also not exist. That's a comment, but it's very important subject that has been discussed, particularly by legal academics within a lot of fora. There's one last comment or question. That's from Michael Exelvenio. You say people are fooled into trusting the law for the safety it provides, but do not realize it is paid for by their freedom. Okay, thanks for all of those comments that you have brought in. Now, let me commence by making you understand that so far, as you have seen through our introduction and flyer, so far, after Ghana discovered its first set of infections, the president rolled up his sleeves, got into action. Parliament quickly passed the Imposition of Restrictions Act 2020 at 10:12. The Minister of Health was ordered by the president, and as you heard the president a while ago, or instructed by the president to do something. And that led to the first law, EI 61. EI 61 was used to declare COVID-19 as a public health emergency, and it was issued pursuant to the Public Health Act 2012. That's Act 851. Then we had EI 62, which was used to close the borders of Ghana and the airspace of Ghana. Then we had EI 63, which was for the emergency communications, curtailing some of your freedoms to privacy. And I think your question will be addressed using that law, EI 63. Then EI 64. EI 64 appears to be what has regulated our life mostly for the period. It brought about the general measures, including no conferences, no social gathering. You can't have funerals, you can only have burial ceremony with 25 people, no church service, among others. Then we had EI 65. EI 65 brought the measured lockdown. You remember the lockdown? Then we had EI 66. EI 66 extended the border closure. Then EI 67 also was used for an extension of the lockdown and the measures, because the measures were had come to an end. Then we had EI 68, also for extension of the measures, and we have come all the way now to EI 110. Mr. Pencil, we want to begin with the first question in mind.
Yes.
His question is, which law allows the Ministry of Communication to, as it were, deal with our mobile money transactions, among other things? Specifically, he's referring to EI 63, the Emergency Communications EI.
Yeah, thank you. I think the first of the executive instruments that dealt directly with the question by the gentleman who asked this question, yes. I do not know how this, and I'm going to adjust it. Somebody should have heard me. But it doesn't matter. It's executive instrument 63.
Right.
And that executive instrument was essentially power given to the government, not in a particular ministry, or to all the network providers to cooperate with the national communications authorities with a view to letting the government virtually access to the mobile phone, everything about everybody's mobile phone. And it was put in the law that it was intended to assist the government deal with the issues arising from the pandemic. So that is essentially the law. Some have raised an issue as to whether indeed it's a bypass to government wanting to do other things fishy with our information, that is to say a breach of our, what do you call, privacy. But that's another matter altogether. For now, it is important to answer the question directly by saying the executive instrument 63 was a power given to the Ghana government, meaning that the government would then determine the agency. But in the law, specifically, the National Communication Authority was the one that was mentioned specifically to be the agency of government to liaise with all these telephone service providers to take that information and as it were, because when I went through, indeed, what was very interesting, a part of it referred to contact tracing.
Right.
That appeared to be the pretext on the basis of which
it's supposed
this information,
to be the main purpose, contact tracing.
Contact tracing.
And this law, all your mobile money data,
yes,
transaction, your wallet details, your merchant code, your bank details, practically your every private transaction details, the telcos were compelled to disclose to the government.
That is so.
So there's a process that is enforced.
That is so.
And the government is aware, and that it is effective in using to get contact tracing. Right.
Yes, that is it. But issues have arisen because if you contrast with the situation in other countries, I may talk directly, for instance, about the United States, where there's a big issue about privacy, people's right to information, and there's a big fight between the security agencies and manufacturers of phones, particularly Apple, where they've put codes and whatever on all their phones and they cannot break, and issues of crime have arisen in which the government has requested these companies to give them access to particular telephones that they have handset that were in their possession, which were retrieved from scenes of crime and so forth. And there's always been a fight, and these companies have not yielded to the government's demands. Even only last week there was an issue like that where government eventually had managed to break the code from Apple phones that they received. So the contrast is, how come that in other jurisdictions, maybe US must be the best example that we'll be talking about, that issue still exists with government's inability. In other words, are the rights of people in the United States better than those in Ghana with regard to privacy? Because the same COVID thing has broken out even with a much serious toll in the US. Is it, for instance, that we are on the plane? But you see, this provides the context within which if individuals feel aggrieved or think that this is a pretext by government to access information that they are otherwise not entitled to. This provides a framework, and this is an issue for constitutional law and for the Supreme Court and so forth and so on.
And as you know, this program is intended to purely educate you to know what to do and what not to do. The aspect that Kweku Pencil has just gone into because of the question from Sylvester is an aspect that legal academics has engaged the minds of legal academics, and they have debated it over the period. So we will let that rest for here and then proceed to the next issues. There was another question. We will take those three questions and then we will return, and Kweku Pencil will have all the time to educate us on almost all the laws. His question is, this is Arno Charles. All this law should have a lifespan of the crisis it seeks to handle. Once the crisis is over, it should also not exist. That is Arnold Charles. Once again, that's another very big question that legal academics have been talking about. No sunset clause, as the issue is. What do you say about that? The laws must expire with the COVID-19.
I mean, that's true, especially if you look at the, first I want to distinguish between the executive instruments and the law that is provided powers to the president. We're talking about Act 1012, that is to say the Imposition of Restrictions Act. To a large extent, some distinction ought to be drawn between it and executive instrument, to the extent that we refer to it even as a law. I mean, it's a body of rules that are made by the executive that are intended to be enforced in the same way, no less a way than the same way all laws are enforced, except with the difference that this comes from the executive arm of government, and it is power that is derived from the main law, which is the Act 1012. So if you look at the intendment and the object of Act 1012, it is intended to regulate activities related to the COVID-19 pandemic. And therefore, even if you look into the law specifically, there are time ranges within which the laws must be made. The regulations that the president is making by executive instruments is not supposed to go beyond certain times. I think, if I remember right, it's not supposed to go beyond 3 months. Any of the restrictions that the president, or any of the powers that the president is supposed to,
So if the president issues an EI, like say this one, this one is EI 68. Imposition of restrictions, coronavirus disease, COVID-19 pandemic number 5, instrument 2020. So if he issues this EI, whatever the instructions and directives he gives in this EI should not go beyond 3 months.
It cannot exceed.
It cannot go beyond 3 months.
If it does, on the face of it, it's a nullity.
All right. But the law allows him to extend it for a period of 1 month, until he has gotten another 3 months. So in total, the laws the EIs that the president issues can have a lifespan of 6 months.
Or even more, because see, the whole idea is that nobody knows when this COVID-19 is going to be with us. And the powers of the president will continue to exist as long as the pandemic is with us. But my appreciation of the limitation that was imposed on the president is to allow the president, by use of his discretion and by consultation, review the situation on the ground as rapidly as he can. And the idea is that as long as the president has got reason to believe that some particular restrictions or particular rules ought to be made, that power has been given to him under Act 1012 to be able to use. That's why he's the president. But what it also means is that, please, let's look at it within this context. I mean, because we live in a democracy and because we have our courts, and so what it means, for instance, is that if it gets to any point in time that anybody gets to believe or think or suspect or somehow becomes apprehensive that there's no real basis for the powers that the president is exercising, that will also become an issue for the courts to decide.
That's right.
Because that's what the limitation of constitutional rule and so forth and so on is. So therefore, even though it appears to be a carte blanche, something open to him, first and foremost, there is a restriction as to how long any particular regulation or executive instrument could last. And two, like once it exists, like you said, it's been, like, for instance, by the issue of those many executive instruments, been extending it 3 weeks, 2 weeks, and so forth and so on. That is the spirit of the law.
So when he brought in EI 64, which said we can't have church, we can't have sporting activities, we can't go to the club, we can't go to all of those things, no conferences and all of that, he gave us a certain period. Once the period was up, he needed to extend it. He issued another EI to extend the life of that EI. Then, when it was not sufficient enough, he issued another EI. And presently, he has issued the EI 11-0, EI 110, to extend the measures until the 31st of this month.
That is so.
By the law, he can have the EI for 3 months. After the 3 months, he can extend it for another 3 months. But
so.
Those 3 months, he must extend for 1 month at a time. 1 month at a time until a total of 6 months come. The question people have asked is, clearly, it means there can be no end to the life of the EI that a president will issue, because by the expiration of a total of 6 months, he's not required to go back to Parliament. He will simply issue another one, which is new, which can travel for as long as 6 months. And then by the end of that one, he again can issue another one, which can travel for as long as 6 months. So practically speaking, there is no time, bound. The EIs are not time bound.
Yeah, I agree with that. You see, given a purposive interpretation to the law that is regulating the president's own activities, what it appears to be the case is that a large room of discretion has been given to him.
Right.
And I've always believed that a president over any country must have the kind of rules and room that he can operate that no one else can. And I think that the particular law that we are dealing with, which is Act 1012 of 2020, I don't believe it was by accident or by the Parliament. It was not an act of omission on the part of Parliament. In other words, Parliament purposed that since nobody knows how this pandemic is going to be around, it is very possible. I mean, indeed, based on what we read from other networks, especially from the US and whatever, people are projecting, I'm talking about analysts, scientists, I'm talking about professionals, are projecting that at the very minimum, we're going to have this pandemic around for 2 years, at the very minimum. And what it means is that all kinds of regulations ought to come in. And since he's the president, obviously, he is the one, the law has given the power to exercise that discretion.
Right.
It is my honest belief that if Parliament had any reason to believe that at any point in time they want to exercise a check on the president's right and ability to extend the law as we will put it ad infinitum, then it behoves Parliament by the very Act 1012 to have put in a specific clause to that effect. Outside that, I will have a serious problem with any contention that seeks to suggest that at any point in time maybe the president is required. Might be out of good faith. As other places, these things are normally done.
Right.
The president may have to go back to Parliament, but as far as I can read the law and given his schedule and whatever, there is nothing that imposes that obligation on him to go back to Parliament.
Right. And the Imposition of Restrictions Act itself has no timelines.
No.
So it's for, as you know, forever until an executive has decided to ask Parliament to, as it were, repeal that law.
No, but I'll say something to that. It's not as simple as that. Like I said, we are all part of the whole system, the whole arrangement, and we are also judges of how the law functions and so forth and so on.
Right.
And what it means is that in spite of the latitude that will be given to the president, the open-ended manner in which the law seems to have been cast, it's an objective analysis, and that is the test of, reasonableness, the test of objectivity, test of right or wrong. And like as I sit here, for instance, if it gets to a point, on the basis of the evidence that we have in our hands, it becomes clear that we no longer have a pandemic to deal with, and now we're standing that for some reason that nobody can speculate, we still have regulations and executive instruments being issued. For instance, that's the real problem that people have with executive instrument 63. Because the point is, even though it came in around this COVID-19 times, it appears that it's an executive instrument which more or less had come to stay. Because the information that the president requires under the executive instrument, under, with due respect, pretext of contact tracing in relation to pandemic, the pandemic that we're dealing with, there seems to be no end to it.
Right.
And whether indeed the executive instrument was cast, because don't forget that it was passed under the Health Act and not under this Act 1012.
That's the first one.
That is so, executive instrument 63. The difference between all the executive instruments that was passed after Act 1012, which is beginning for executive 64, 65, and everybody, they all find their roots in Act 1012, and therefore it can reasonably be argued that once the purpose for which Act 1012 was issued passes, then everything founded on that foundation will fall. But not with Executive Instrument 63 dealing with telecommunication and all our information and so forth and so on. I mean, that's the way I'm looking at it.
All right. We have the next question, but the mischief that people think that the absence of a sunset clause, that is a clause that terminates the law, the life of the law when coronavirus ends, the mischief is cured somewhat by the circumstances for which the president can issue an imposition or a restriction. When he issues the EI, there's a guideline. He just doesn't get up and do anything he feels like doing. The law says if he's going to issue it, it must be reasonably required in the interest of defense, public safety, public health, or the running of essential services, for example. So if what he brings as an EI does not meet these requirements, if it is not reasonably required for public safety or for public health, it can be challenged. Let's go to the third comment or question that was asked, and then we will now spend time to go to the specific do's and don'ts and what you risk if you don't respect the law. Right. So this was Michael Excel Vigneault. He said people are fooled into trusting the law for the safety it provides, but do not realize it is paid for by their freedom. How do you translate what he just said?
I think this person made some philosophy classes in the University of Ghana and wishes to philosophize this issue. Essentially, obviously, we all, we lose something, we contribute something. Our restrictions are imposed and affects us in ways that possibly we cannot even speculate as we sit here. So the idea I see him conveying is that even though the law comes in for the public good, it requires all of us to make certain sacrifices, and that those sacrifices must be worth the making. In other words, if the president imposes the kind of restrictions, the one, for instance, that lasted 3 weeks, that restricted movement, the lockdown, that restricted movement from places to places, what it meant was that was in our own good, that we should observe the law and as well as the protocols.
Even though it took away our fundamental human rights. Let's go to Zoom. Someone is joining us, and the statement Vigneault made is so true, because by these laws and EIs, our rights and freedom of movements have been restricted and sometimes completely taken away, like he just said. Our freedom to practice and manifest our religion, for example, has been taken away. You can't go to church. Your right to privacy. He just referred to EI 63, which we discussed to the first questioning. The Constitution in Article 18 says the privacy of your communication or correspondence should not be interfered with except under certain circumstances. Okay, Sandra is joining us. Hello, Sandra. Sandra, you're on. I think your mic is muted. Okay. Hello, Sandra.
I can hear you loud and clear.
Good. Let's hear you.
Yes. My question is about Article 31, where the president has the power to make law in terms of emergency situation. And as your guest said, usually the EI has a lifespan of about 3 months. It could go for an extension of 6 months. But like the situation that we have this emergency the emergency power that the president exercises in Article 31, is there a possibility that this pandemic, what happens to Ghanaians who traveled outside the country and are yearning to come back to the country, back home? Now their lifespan or their visa gives them an expiration. So with that, their inability to come back to Ghana has made them to be illegal immigrants. Is there a possibility that the government of Ghana can do something and then bring them back home, just like the way we've been able to receive Ghanaians from Kuwait? Thank you.
Right. So the president has not used Article 31 to declare an emergency. But what she's saying,
yes,
she has an understanding that since the EIs he issued have a lifespan of 3 months and can be extended for another 3 months, it means for 6 months somebody may be stranded. Can you educate us to understand, doesn't the president have power to even shorten the time of an EI?
No, he has. The president has got powers. For large, I mean, he's got more than powers, if I may put it that way. Because, like I've said, the executive instrument 1012 is the object of it was to empower the president to do all necessary things that are required to take us through this pandemic. And what it means is that it only requires political action on the part of the president to be expressed in an executive instrument. Because we know as a fact, for instance, that lots of governments are taking steps to bring their citizens from other countries. Nigeria has been doing it. Yeah. We know, we read it at least in the press, and we know that they did it. So in my honest view, it's more to do with the president's political action, because everything that is being done here is once he decides that he wants to do it for the betterment of Ghanaians, in the interest of Ghanaians, then he requires an executive instrument to be able to carry it out. Right. I require that when this whole thing started, there was a clamor about Ghanaians in China, in particular, to be brought home. Right. And with due respect, the attitude or the response to government was, with due respect, more like a joke. Unless, of course, what I read in the papers did not really reflect the attitude of the executive. But at the end of the day, no Ghanaian was brought home. Right. Thank God nobody has died. But the issue the lady has raised is a very, very critical one.
So the issue she raised is more specifically in Section 4 of the Imposition of Restrictions Act. There is a provision in subsection 2 that says that when the president issues the EI, he has the power to shorten the duration of the restriction. And he can also extend. So I think for you thinking that because the restriction can last for 3 months and another 3 months, cumulatively 6 months, means that people will be stranded.
No, but I don't really believe that's the issue.
Right.
Though I appreciate her concern. The issue has to do, listen carefully. I mean, like the people who came yesterday from Kuwait. Yeah. It required a presidential decision. They were deported, but the president could still have said our borders are closed. We can't allow you in because strictly, according to the law, the borders are closed. The ones that are closed, they are closed. Right. So the real point that I'm thinking of is the fact that it requires a political action on the part of the government to be able to make specific exceptions to people who are coming. Because why? Our borders are closed, but US, UK, Western government, they are taking their people out of this country.
Whilst we issued the EIs that closed the borders in our airspace, they still were able to come and take their citizens away. Our government granted them special permits.
That is so.
Our government tells us that it is gathering data across the globe about our citizens, and as and when it is prudent or the certain criteria is met, Ghanaians who are stranded elsewhere will also receive special permit to be brought home in the same way like we have the people from Kuwait brought to Ghana yesterday. So can we now go to the EI 64. EI 64, more specifically, if we got to, I'm sure in paragraph 1, where it actually starts, imposition of restrictions. There is imposed by this instrument restrictions on 1, public gatherings, including conferences, workshops, funerals, festivals, political rallies, sporting events, and sporting clubs, private parties and other social gatherings, nightclubs and event centers, and religious activities in churches, mosques, shrines, and at crusades, conventions, pilgrimage, and other religious gatherings, and travel to Ghana. What does this mean effectively?
No, this one was to, with respect to the whole of Ghana. It's important to qualify it that way. These restrictions apply to the whole of Ghana. What it meant was that unless there is express exemption given to you under the same executive instrument, you were not to engage in any of these activities that the president has specified by this executive instrument. And it is as clear as the daylight or the sunlight, and admits of no ambiguity whatsoever. Except that issues can always arise based on what specifically somebody claims to be doing at any particular point in time. Because a conference is a conference. And for instance, the issue of EC comes to mind. What they said they were going to do, and some people sought to enforce it by, what do you call it, injunction.
Conferences, workshop, what exactly are the differences here? When you say conference and say workshops,
a workshop, from my understanding, a workshop is essentially a program put together by one particular, what do you call, an organization within itself. It involves its own personnel and so forth and so on, to look at any aspects of their own activities and so forth and so on. Well, I think in a broader context, it may also include other people who are specifically invited. But in terms of the activities, a conference and a workshop is the difference between who is who and who is present. Because every time we talk about conference, we have in mind people coming from outside and so forth and so on who are coming. But workshop, from our understanding, is typically, that is so if Joy FM decides that they want to do something regarding their things, then they bring in their own people, they sit around a table, and they know how to do it.
There is an aspect of the law that has brought a lot of confusion to people. And some have suffered, have been put in jail, some have been fined. And like the police informed us, at the time the lockdown was being lifted, we had in excess of 400 people who were due to be prosecuted for violating the social gathering prohibition. Because the law says private parties and social gatherings have been banned. Social gatherings. So can't I have, like, you know, a Christian have a cell meeting? A cell meeting where around my community, my vicinity, about 4 or 5 people can gather and study the Bible. We can't do that.
You know, the law is itself subject to interpretation by the courts. And what interpretations that the courts give to it must be reasonable and accord with reason. I mean, accord reasonableness.
So if church people came to you and asked you this question, what would have been your response to them? A group of people to around the place, you know, these clubs that meet for self-help, welfare things. They want to meet, and they are sure that they can assure themselves that they will distance themselves enough. They will go through all the social, you know, the protocols. Can they meet?
You see, my attitude to this issue, including advice that I've given to people, is that if it is possible, avoid it. Because it's a very cagey, it's a very, what do you call it? But I mean, even, see, this issue possibly ought to be put in context against the background of EI 65. EI 64. No, this is 64. But it comes into sharper focus if you include EI 65. Because it was EI 65 that even then added another layer of restrictions to EI 64 in terms of where, I mean, that's restrictions
you just can't
outside.
Move.
That
you
is
can't
so.
go away.
But that place,
unless you are essential service
you're
provider.
very right. But I found very interesting exceptions to that place, and that made it very interesting. Unless, for instance, we're going to pay for utility, unless we're going to use the public toilet, unless we're going to buy food. So that is where the interesting thing came. Because if you saw me, I understand somebody was in a car, was stopped by the police, a joke that people buy, whether it was true, but it was on social media, and they asked me, so he's got a wife.
Yes.
He's got got 3 wives. One was another place that he need to go and give a chop money and so forth. So it's essential. When you ask me that question as a lawyer, I can say that the circumstances, the peculiar facts of every case could be determined. Because
so if you said you are gathering for a cell meeting, home cell, that's a religious activity.
That is so.
The law has prohibited that. If you say you were gathering as a welfare group to do 1 or 2 things, or even to come together to study, that's social gathering, that's prohibited.
That is so.
Okay.
And like I said, my first reaction, my reaction to this thing is don't, if you can avoid it.
Okay.
If you have to do it, no. Because I'll tell you a true situation. Because some church members called me and told me that, oh, one of our branches, we are not many. And when we meet, we can just whatever. I said, listen to me. What the president has just said is not just something he just says. It's got the backing of the law.
Right.
Meaning that if you engage in the activity, the police may turn up. When they turn up, they will arrest you. One thing that I'd like you to know is that if you indeed want to put your own faith on the line by going to do that kind of thing, anybody that you invite to the occasion, you must tell the person that there's a possibility the police will come, but when they come, you shouldn't run. You should be able
we just
to
saw on the screens these 3 pastors in a church in the Volta region. These 3 of them, they got arrested by the police, they were prosecuted, and they were fined, I think 13,000 or so. They couldn't pay, and so now they have been put behind bars for, is it 12 or 13 years. They went to church.
Yes.
You can't say because the provision, the confusion, and that's what I want you to explain to us. The law makes an exception. It says, despite paragraph 1 and 2, a private burial may be carried out with not more than 25 persons in attendance.
Yes.
Does this mean that I can organize any gathering with 25, not more than 25 people, and I'll be safe?
The answer is no.
Why?
Because a funeral, for all of us who know our culture, our customs, or whatever, is a different and a special
It's
occasion.
a private burial. Private burial.
Yeah, so what I'm saying is that
Funerals are prohibited.
Funerals prohibited.
Yes.
So you're talking about a burial. Don't forget, even though it's separate, they relate to one another. Because from a funeral, that the burial comes, and then we have a funeral. So burials are normally characterized by large numbers of people, and they have been particularly accepted by limiting the number of people who can follow any such burial activity. And please, I will not extend that category of activity and then add it to anyone else. Because
so there are people who have said, the law says private burials may be carried out with not more than 25 persons in attendance. What it means is, I can have a wedding with 25 people.
Please, a burial and a wedding are not the same thing. I will not give that advice to any client of mine. I wouldn't do it. It's not fair, it's not proper, because a burial and a wedding are not the same thing.
Okay.
And if you go and have a wedding, even with 24 people and they arrest you, they will prosecute you.
If I live in a house, a compound house, and we wanted to celebrate the birthday, right within the house, we are not calling other people outside to come in.
Yes.
If the law says private parties and other social gatherings, does it mean the house, the people who want to celebrate the birthday of whoever is there, we are prohibited? We are not inviting people from outside.
I'll try and give it a very, very purposive interpretation. It's a good question. In Ghana, we've got what they call compound houses. And what it means is that we've got a lot of people within that house who may even outnumber 25 or even 30, typical compound houses. I think my clear understanding of this law of a party is that of people coming from different places and coming to congregate in one place to have that party. And therefore, it is with that in mind that that restriction has been imposed. What it means, therefore, is that if you live in a compound house, you are already there. There's absolutely nothing you can do. But, you know, I'm just trying to give myself some room for people to appreciate that when the law has legislated one way, you must be careful if you want to break it. because sometimes relying on purposive interpretation, whatever, may give you trouble. So the extension that I would draw, according to the example that you gave, if we're all living in one house, there's clear evidence that we all live in one house. Please, with due respect, there are places in this country when you go 10 people in one room. So the next room may have another 10, another 10 in another room. And there's absolutely no restrictions in those 30 people.
So we can't do it.
House. No.
We can't do it.
No. I'm saying that I would draw that extension based on the extension that you have also drawn.
Okay.
That if the evidence is clear that all these people are already within that place and there's absolutely no way that they imported somebody from outside to exceed that number, then in my honest view, they can have that event, have that activity.
Must they import somebody to have what is known as a private party?
A private party means that you will limit the number of people or the category of persons as
So does it even matter that you all live in the same house and you are organizing the birthday party for the person? Because it says private parties. So for as long as it's a party, it's a social gathering, it's prohibited. Is that not the case? It doesn't matter that you all live in the same house.
But if you're a family, if we're one family, I clearly get your question, but I will answer it very positively. You don't know the people in this country have got 4 wives, 5 wives, they all live in one house. Maybe it will be restricted or limited to the peculiar circumstances of the particular case. Other than that,
we have a doctor. Can we have Dr. Arthur Kennedy? Hello, Doc. Hello. I think your audio is muted. Okay. Hello, Dr. Arthur Kennedy.
Hi, good afternoon.
Good afternoon. Very good to hear from you and to see you. Please, let's hear your contribution.
Let me listen a little bit. I just tuned in, so I will listen a little bit, but thank you for acknowledging me.
I can see that you are at work.
That is correct.
We wish you a lot of safety. Right. Okay, so that's Dr. Arthur Kennedy. For most of you who his name is doesn't need any introduction, right? So on that point,
yes,
you know that one other person was prosecuted and fined, and I think eventually he ended up in jail for organizing a private birthday party. So do you take the view that it depends on whether there are outsiders coming in, and it depends on the numbers? The question is the purpose. Is the purpose not to avoid the party at all so that you don't catch the disease?
I agree with you, but you know, for instance, every social distancing protocol breaks down at the level of the home.
Okay.
When I get to my home, my wife, even if with due respect, she's, what do you call it, found to be with COVID-19, I still can't avoid it. My children and so forth and so on. When I go home, I don't wear my face mask and so forth and so on.
Right.
So there is an extent to which every social protocol breaks down when we are dealing, and it's even very funny. Even when we go to our offices, somehow because of the whole idea of having been together all the time, there is this conception that makes us think that it doesn't really matter. We try and follow the social protocol.
We are running out of time, but you say your advice is that just avoid it.
My first advice is just avoid it.
Just avoid it.
Just for the avoidance of doubt. I wouldn't advise you to do it. You cannot be too clever with the law, and all your argument may not be too attractive to a judge. Yes.
All right. Thank you very, very much. And you have been listening to our guest for this today's segment of COVID and the Law. Kweku Pencil is managing partner, Pencil and Co. There's a question that came in rather late, but I can say something in 30 seconds about it. About whether or not you can be prosecuted for not wearing the face mask. There is no law on it yet, but the various assemblies have a way and their bylaws by which you may be arrested if you violate their processes. This has been covered and the law. Let's all respect the processes and the protocols so that we can stay safe. Have a good afternoon.